Good evening, distinguished guests, respected speakers, and fellow attendees. It is great honor to welcome you all back to the conference. This panel discussion will be on new approaches to address local concerns in international economic law. Let me introduce respected chair and other panelists. Professor Katrin Kuhlmann, Professor, Graduate Programs and Faculty Director, Center on Inclusive Trade and Development, Georgetown University Law Center. Professor Katrin will chair the panel. Other respected panelists are Professor Amirthalingam, Professor of Law, Tamil Nadu National Law University. Mr. Pushkar Reddy, Research Fellow, Center for Trade and Investment Law. Mr. Jamshed Ahmad, also Research Fellow at the Center for Trade and Investment Law. I cordially invite the Chair, Professor Katrin Kuhlmann, to proceed with the panel discussion.
Thank you so much. Good afternoon. I hope everyone had a nice lunch. We will make sure that we keep you awake after lunch with this great panel. It's an honor to be here and to have the opportunity to chair this discussion. We are going to talk about approaches to address local concerns in international economic law. We've had so many great panels, I think, looking at the local dimension across a range of issues: health, investment, trade, environment. And I think this session really gives us an opportunity to reflect on everything that we've heard already and talk about then what some of the approaches and theories and models are for actually building this into international economic law. Part of this conversation is grounded in theory. This is something, of course, that we love as scholars, and those who are writing and thinking in this area to think about what is the theory behind all of this? How do we center these local approaches in something that's a bigger framework? I think that there are many aspects of theory that will come up in the discussion. TWAIL, Third World Approaches to International Law, certainly is one that has impacted my work. I'm looking forward to hearing about that transnational law, transnational legal ordering, as we talked about already in the opening remarks by my colleague, Professor Schaefer, new legal realism, socio-legal studies, so many approaches, I think, that impact this. Some of you know I've been working on an approach called micro-international law. And I think if you look across these approaches, they all bring really critical dimensions to the discussion. Some of them emphasize the role of domestic law, many of them do. Many of them emphasize the importance of bottom-up approaches and bringing stakeholders into the discussion, and that, of course, has been something that we've really talked about across all of the different issue areas.
Nurtured
Micro-international law, I will just very briefly say,
representing
speak much
the
more about it tomorrow, but it really prioritizes the granular, the smaller scale intervention, and not in a way that is isolated from the bigger picture, but as something that can really inform the bigger picture, as we see in other disciplines, by the way. So I think law maybe needs to catch up a little bit with other disciplines. I think it's a proposed field of study, as many of these others are. I think it's also something related to practice and implementation. And I think, so I want us to talk about all of these different things. I want us to talk about some of the theory and the approaches that, we might look at as scholars. I also want us to think about the practical side of all of this. How do we really make sure that international economic law and international law more broadly are reflecting local micro approaches in practice? And then I think also, I hope that we can talk a bit about the norms that underpin all of this. This has been something that has come up already in the conversations. Are the norms underpinning international economic law still the same norms that we need to face the challenges of today? Or do we need to refocus and reprioritize somehow? So this is what I propose that we do, cover these different aspects with this esteemed group of speakers. I know that we will do a lot. I'm going to try to keep it conversational, so forgive me if I interject with questions. And we will have plenty of time, to engage with the audience too. So please think about some things that you'd like us to cover. So, I don't know who volunteered to start. Professor, did you volunteer to start?
Whichever way is convenient to chair, I have no problem.
Pardon me?
Whichever convenient chair feels we can.
Maybe we'll turn to you first. I think you have such an interesting background, as I was telling you, that one of the things that really struck me immediately about your background is that you have a background in science as well as law, and I think that that combination is one that we could all benefit from, certainly in the context of what we've been talking about. That you've worked on issues ranging from environmental law to human rights, energy, science, as all of these intersect with international law. So I would love to hear your thoughts on what approaches you think should take priority as we really think about how to center and prioritize the local in the context of international economic law's future.
Good afternoon. Thank you, Chair, and congratulations to the organizers. And thank you, Pushkar, for bringing me to OUSL and Sri Lanka. Yes, so last 6 sessions, we had a different dynamics of the working of international economic law. The theme of this particular technical session is why the instruments and the institutions have to work for local approaches. It has many connotations, as our chair rightly pointed out. As a student of international law, having science background and researching on why the harmonization between binding instruments and the non-binding instruments is a precondition as and when investments are attracted. So my fold of discussions, my discussion is these 6-fold. When I was referring to this particular event, I understood there are 2 interesting contributions which are made by Honorable Supreme Court and the International Court of Justice. Having the realization of concept of sustainable development, our Honorable Justice is sitting with here, and the same period Justice Kuldeep Singh also. When there was a discussion on whether states like India has to prioritize for more investment in order to give more economy, more employment opportunity, reduction of poverty. The novel observation given by the Honorable Supreme Court in a leading case like other day, or Pushkar also, Aisha also rightly mentioned many cases. One of the leading cases, Vellore Citizen Welfare Forum. The observation what Honorable Justice Kuldeep Singh made, it has to be followed, because morning one of our learned panelists, she was very particular why we are taking only from India's perspective, which made us to not to include any neighboring states like. Since we are dominant players, sometime it is subject to within inverted commas, both development aspects as well as creation of institutions and instruments. So most of these countries have a chance to take.
Meaningful collaborations.
The novel observation given by Honorable Justice was the legal elements of concept of sustainable development, precautionary principle and politary principle have to be taken as a part of as and when institutions like Parliament are taking any economic decisions. That's what we are here. The second interesting case, again I have to appreciate the Honorable Justice G.C. Veeramandri from same Sri Lanka.
Boardroom of the Faculty of Natural Sciences and Boardroom of the Faculty of Engineering and Boardroom of the Faculty of Humanities and Social Science. Our organizing team is available to assist and guide you to appropriate technical session menus. Should you have any questions or require directions, please don't hesitate to reach out to them. Thank you, and we look forward to the enriching dialogues and collaboration. Thank you.
Afternoon session when we are about to conclude, Honorable Professor Sondarajin sir recommended to us. In the early 90s,
and
the
guide you to appropriate
institutions
technical
are very
session venues
particular to codify the international law. Mere
Engineering
because of
and board
various specialized instruments and institutions, why we have to go back with the fragmentation? That is novel observation. The point
On
which I
behalf
want to make,
technical
in the
session
name of local approaches, how we can take the
Yes.
references of various elements of sustainability. Because is it a duty on the part of a state to have an approach called QT based or right based? Whether the duty and right between the investors and the recipient, is it on a basis of legal or equitable? That's a premise in which I am going to continue next 4 segments. What is legal? Whatever instruments from session 1 or panel discussion 1 till last session and all set of ABCD presentations. The panel members as well as presenters heavily relied on most of the instruments which are created. Other day, our professor also mentioned 1883, Paris Convention, Pan Convention on Industrial Property. The Lordship also heavily reviewed 13 of BIS of Industrial Property, Intellectual Property. All these requirements of rights based. But later 80s, in the name of Declaration of Right to Development, permanent sovereignty over natural resources made the institutions on equitable base. That's what when I was discussing, I specifically appreciated the interesting contribution which was made by learned Edith Brown-Weiss. In her article in the name of Intertemporal Doctrine, she was heavily relied. Why these investors, these traders, these service providers have to move on with equity? Because morning, both presenters in the technical session 5, they really mentioned, no, states have a need to. And yesterday, our Mr. Goswami also rightly mentioned. So when you have a crib, which made you to not to exhaust? When you have effective crux, effective control, definitely all investors might. That's what morning again. The chairperson was rightly mentioned. No, we have to take care. Okay, the point which I want to make it to the floor and learned members, how these economic instruments may think of to use most of the equitable principles. I'll make 2 interesting principles from the Rio Declaration. Morning also our Pushkar was mentioning about principle 10 of Rio Declaration. It has 4 lines. The last line is very, very novel. As and when states are going to enjoy any trade or investment, here I have to make, as a student of international trade law, I have to make a very specific pause. The WTO instruments and the IMF are heavily working only on trade and services. But later point, the evolution of various instruments like BITs, RTAs, IAFTs and IAAs make them towards investment. So what is the precondition?
Could I ask you a question, actually?
Yes,
I'm
please.
very glad that you mentioned, and I'm glad that you do it in a way that's very, I think, bottom-up, right? Very local, looking at these court cases, talking about how some of these principles and norms are interpreted at a more national level. It's interesting to me if you look at international economic law right now to see where some of these norms intersect and sometimes conflict with each other.
Yes.
The preamble to the World Trade Organization, for example, mentions sustainable development,
Yes,
right?
you are absolutely correct.
We have also, and that would bring in equity
Yes.
as well. But if we look at the way that the rules are designed, they're really often designed to prioritize the economic pillar over the social and even the environmental. this principle of equity is not something that is embedded in international economic law very consistently or very robustly. So what do you make of this? Do you think that, would you argue that because the principle of sustainable development is at least referenced in some of these instruments, that provides kind of the ability to pull it in more fully? Do you think we need to shift norms somehow? Do you think we need to refashion these instruments? What would you suggest?
Thank you very much. I think it's very novel intervention by my learned chair. I think during the technical session 3, there are two aspects are repeatedly discussed. How the ICSI the institution will, even when Professor Swarnarajan was responding, when there was a question without an ICSID whether investment would move. The beautiful answer was given by our learned emeritus professor. Yes, it is a part of the system. Whether we have an institutions or not, it's an immaterial. The point which I want to make, one more observation what they made, they used two aspects. One was on the role of third parties. The second, out of 5% asked, 2% asked used a novel concept called the role of judiciary to active role. Where my simple observation is, as and when, I think one of the professor from same OUS, she was referring on Article 31, 32 and 33 of Vienna Convention Law of Treaties. Okay, all this I am bringing only to make my substance. The international dispute settlement bodies are expected to work based on sources whatever accepted. So we know 38 subclass 1 ABCD of the Statute of International Court of Justice, where there is a treaty. But many of these are not in furtherance of. That's what morning also one of the local professor from OUS, when he was speaking, he brought how the local practices are. So when these things are not codified as a part of domestic law or regional law or international law. Regional law means domestic economic instrument, regional economic instrument and international economic instrument. Is it a license for the investors to simply derogate? As a student of law, teaching international economic law, it is not. That's what we are thinking a higher end of. Especially whenever we are thinking of biodiversity. Morning also Professor Gandhi was rightly connected with. And James sir also mentioned about UNFCCC and CBD. So these instruments were brought before the World Trade Organization preamble, what you rightly mentioned. When we check out with the GATT preamble and the WTO preamble, except the sustainable development, rest are there. But last session when they are speaking about SPS, DBT, SCM and ACA, most of these novel concept of equity are there. Let me substantiate with the Indian practice of 3 contribution. In 1996 there was a novel case. Again, we have a lordship. So MC Mehta versus Kamal Nath, where Honorable Supreme Court brought a novel concept called public trust. It was not a part of legal. The second interesting novel concept what was accepted, intergenerational equity. The third and novel concept is mass start auction or parents patriae, absolute liability. Because these are the concepts and doctrines which were discovered by the Honorable Supreme Courts in order to ensure how the people interest are. I think yesterday both the last was
Thank you.
You're bringing us back to the
Yes. So all these are bringing to make my substance by saying non-institutional stuff. International diplomacy, geopolitics, it is impossible to check and sometimes coerce. This statement is not relevant because no agreement can be concluded with the coercion. But still, when there is a need for development, last cases, some so-called given.
Thank you for that, and I think that is a really nice way.
So the last part, the last time, as and when there is a development, people and the stakeholders are expected to inform within advance on two contexts. What was what all racial members. Second one is what all activities. This is a novel concept. Because unless these things are informed to the people who make it a definitely we will get more. So morning also, one of the panelists said, after having necessary compliance would lead for many litigations. Practice are also rightly mentioned to our Pushkar. Not only the same case, whatever reported by Georgetown, because culture is part of the environment. We can't make any exclusion. So all these can't be otherwise rectified in the name of legalization.
This is a very good final point. Let's come back to that maybe in a little bit. And I'd like to turn to our two gentlemen here. Maybe Pushkar, I'll start with you, and thank you, by the way, for all that you did to bring this together and to put these issues. You deserve more than a round of applause. I mean,
I think you clap for Professor James.
And Professor James, of course. But I know that you were, had a vision for how these conversations could unfold. So I really, really appreciate that. And Professor James, of course. So how do you see this? I know you and I have talked a little bit about some of these other theoretical approaches and how they maybe kind of complement each other, where your research
and
is
social
focused. I know
science.
you've done a lot of work on Twales.
Our organizing team is
example.
available
It
to
would just
assist
be
and guide you to
interesting
appropriate
hear
technical.
How you position all of this. What do you think that we should be doing in terms of approaches? What should we be looking at? What might we emphasize even more in the future? So I turn to you for your thoughts on this.
If I can actually just play on some of the things that Professor Amirthalingam mentioned, is that the domestic and international are closely intertwined. And I'll come to Twale in a minute, and that really brings down to, and I'm really not as qualified as Professor Schaefer. I talked about transnational legal systems and processing and ordering, and that this idea of making a distinction between domestic and international isn't necessarily representative of how the system works. And like Professor mentioned, is that you see how domestic sort of jurisprudence really affects international legal norms. And we're really surprised by how this works. So if I can really simplify this through Harold Koh's sort of conceptualization, and I'm sorry if this is a little theoretical, but this entire panel is based on a methodological way of looking at local approaches. It's the computer age imagery. And he talks about in the context of how norms from international institutions can be downloaded by domestic legal systems. A domestic legal system may create a norm which is adopted at an international level but downloaded at another domestic legal system, or they might be transplanted from one domestic legal system to another domestic legal system. But of course, as Professor Schaefer has sort of identified in his own writing, is that it's an oversimplification of the process, but it is in fact, I would say, a fun explanation of how it works. And I think this is a great way to look at local approaches, is that sometimes we'll be surprised by how international legal instruments are really implemented or interpreted at the ground level. And I think Professor Kuhlmann also talks about it through this idea of micro-mapping, where we see these micro-interventions and how these different forms of interpretation really define how international law is really implemented. But now coming back to Twale, and I'll always have a soft spot for Twale, and it's really sort of relevant to the theme of this conference, to look at local approaches, because when you look at sort of the early conceptualization of looking at the lived experiences of people and how that's relevant to international law, we're looking at Balakrishna Rajagopal's International Law from Below, for instance. And although I wouldn't say it's the perfect system, because in his book he talks about the context purely in terms of grassroots levels movements and resistance as a means by which local actors can affect international law. But I think it's not always that violent. I think sometimes it's more organic. And that sometimes local actors, and again, we have to come down to how we're defining local actors. It's not just non-state actors. We know that private actors can influence international law. I think this idea that international law is purely state-driven is a thing of the past. I think we now know that private actors, like through ISDS, or even say the Berne Union that Janet Levitt talks about from bottoms-up lawmaking, is that the Berne Union, for instance, is conglomerate of these really influential private actors who were able to influence the SCM agreement. So now, but what about the really local, the hyper-local? We're talking about MSMEs, consumers, indigenous peoples, which we talked about time and time again. We need to reimagine how we look at international economic law, or rather international law in general. And once we do that, we're able to see sort of these new innovative approaches. And I think this really reminds me of, again, coming back to TWAIL and James Garthy's piece of the promise of international law, which is that once we reimagine the epistemic sources of international law, we can actually find new solutions, perhaps more effective solutions to problems we have now, which international law has not adequately tried to remedy.
Absolutely. TWAIL has really inspired me too. And it's something that I bring into all of my teaching, and my students, I find, always just absolutely fall in love with TWAIL because it is such a powerful way of thinking about, as you said, reimagining the system. What have we done that needs to be rethought and re-envisioned? But I think one of the things that I often come back to is how do we do some of this? Because it's complicated, right? And I think even in the last panel when we were talking about standards and SPS and TBT, there are these disconnects. We can think about, and go and speak with MSMEs and women and, local communities and listen to their views. And somehow, though, then that needs to translate back up into this very high level. I really appreciated your remarks on learning more from the domestic level. And you're absolutely right. I think that the jurisprudence is something that we need to study much more. But I find that there are so many disconnects in this area. There's still so many gaps that we have, despite all of these ideas and the theories. And we still, in practice, are not always able to do this effectively. So that's one of the things I'd love for us. I'm putting that out there as something to think about. How can we make this work better in practice? How do we change, how things operate in Geneva and DC and capitals, and really make sure that that kind of micro, granular, local dimension is coming in? So think about that a little bit. I want to turn to you too, and I know, that one of the things that we had spoken a little bit about is the socio-legal models, which I think are, again, another really compelling way of framing all of this. So please don't feel limited by that, but would love to hear your thoughts on this topic too, and then we can go back to some of these other themes of the discussion.
Thank you, Chair. So by way of, first of all, looking international economic law as a subject rather than discipline itself. And when you choose a thing as a subject, you are free to further explore the approaches. So what social legal economic approach, social legal approach to international economic law? So basically, it is not confined to analyzing the legal text itself, but also looking into the context and the subtext to either to get clarity of that context and the legal text, or if required, to further review to change it. In other words, that socio-legal approach to international economic law is not confined to the black and white letter of law, but the context of the legal text in which it was created, used, misused, abused, or reoriented for the purpose. So it is a broader dimension. It is a actually interdisciplinary approach where you look at how the text has come, and where you look not only the text but also the context under which it has been developed, and also the subtext. Subtext is more broader, which reflects the aspiration of the context, whether it is coming from, and it can be happen at different level. And what you say is that granularity. So basically that approach is more diverse. Somebody was telling that these unilateral environmental legislation basically also reflect the culmination of the social movement for the environment protection, and we have seen that there are several unilateral measures has come bring by the European Union. So if we go through the social legal approaches, it's that measure actually the context of that measure. What is the context of that measure? What's the context of the CBM for deforestation regulation for that matter? Actually it's reflect those movement of environmentalists are doing in European Union, or it is something else. So this can be approached by going through the legal, social legal approaches to international economic law. It's a broader approach, and I must say that it is an interdisciplinary approach which scored to the text, and more importantly, the context under which the text has developed and used. So this is the way to, and when we say that if required, that to reorient that to the text that has been agreed. So the reorient is a very important aspect of this panel, is to engage the local actors if required, is the reorientation. And we have been seeing that there are the writings of these approaches or social legal approaches to international economic law. What I believe is that it is one of the important approach that can entails the voices of the local actors by going through not only the legal text, which is the legal positivist analysis of the text, but also the context in which it was developed or created, and also the subtext, which is the aspiration of the context in which the broader interpretation of the text is allowed. So this is my submission on the approaches too.
That's excellent. I really appreciate that too. I'd love to maybe give an example and then ask a question for all of you about this. So one of the issues that I have worked on for many years and have been very active on recently is international trade and women. It's something that if you travel around, as I have done, and you speak to women, there's a tremendous impact, potential impact of international trade rules on women's livelihoods. But what you're saying, I think, has been missing in our approaches. They haven't been contextualized. So what we're seeing now is this proliferation of incorporating gender provisions and provisions on women's economic empowerment into trade agreements. But most of them are, I would say, kind of ticking a box a little bit. They're putting the words in, they're putting in maybe a nice, mechanism for governments to collaborate, or maybe to incorporate women's voices a little bit more into the process, but they tend to be kind of surface level. They're not really getting at the challenges that women face day to day. The context is missing. And so I've written about this quite a bit, and I've come up with different, proposals on it. I think if you think about it, every aspect of international trade law is going to impact women. But I also know from doing a lot of consultations with women's groups, they're not always going to dive right in and talk about how to restructure the SPS rules. They're not going to dive right in and tell you how to change trade facilitation, maybe a little bit more there. They can tell you, very concretely, here are the challenges that I face at a border. Here are the safety issues that I face. Here are the, the real live challenges. But I'm just wondering, what do we do about that? What do we do about the fact that the context, as you say, is absolutely critical? But in reality, then, you have the architects of international economic law. I used to be a trade negotiator, right? You have trade negotiators who are sitting down writing these agreements. You have those government officials who are negotiating. They don't know the context often. They're not hearing about that. They're hearing about other problems from others that they maybe feel that they have to prioritize. So what do we do to make sure that that contextual approach really comes into these discussions? And I open it up to all of you. Are there other examples where you've seen something has worked well or has not worked well? But I think that's a challenge that we still face, right? We're calling out a lot of the issues, but I think we also need to think about how are we going to make this work in practice. And every panel that I've listened to so far has identified some really concrete problems and some really concrete solutions or potential solutions. So what do you think about that? Could you tell us maybe some things that you think would work to change the dynamics and change the course of international economic law? Would you like to start, Professor?
Yes. Thank you, Professor. I'll make only 4 references. I'll repeat what I said by referring participation. As and when we understood who all are the stakeholders, as we are making a different terminology like indigenous or local community, any gender based or sex based or minority or language or oppression including women, how it could be realized, where only the instruments whatever is otherwise codified necessitates the state which they are going to get a benefit. That's what even I began with, duty based. It is not only their choice, because the instruments like permanent sovereignty over natural resources and the declaration of right to development demanded equitable approach is the preconditions, whoever it may be, whatever context what our co-panelists mentioned. So if a state which is not possessed with adequate technology or finance, as an inclusion, because now the government of India like mechanism, I think Professor James and his James would have appreciated, since they are making many WTO discussions on why the inclusion is a preconditions. Inclusion is a very broader context. Since chair opened up with the only sex space like women, I am making, because even transgenders are. So when it is a precondition, whenever there are no technology which is available to the states, how these group have been identified, what nature of services and benefits these people may be given with or conferred with, where only the duty-based approach come. The second aspect, I said, the self-determination. Morning also, Professor Gandhi sir was rightly mentioning about inclusion of economic, social and cultural rights. Again, you can try to exclude economy and the social, but as a part of culture, when there are no representation. It is impossible on the part of institutions. Therefore, as and when states are going to attract investment, the inclusion is a precondition. As a part of an inclusion, people are expected to be consulted. Through the consultation, their right is ascertained and their fundamental freedom to self-determination is otherwise conferred with. So if an institution which fails, it is a failure on the part of a state to not to demand from the investors whoever will suppose to have otherwise quantification. This is my approach, Professor.
Excellent. No, I really appreciate that. And I will say, I'm glad that you emphasized access to finance, because I think, again, when you speak with women traders or small businesses, it tends to be the first thing that they talk about.
Yes.
And another thing I think that I have heard time and time again is a rights-based approach. I was having a conversation earlier today about the fact that this is really about people. All of this is about people. And yet we sometimes forget that when we're designing a trade agreement. We forget that this is really about making sure that individuals can use whatever that instrument is to their benefit. And there are some models that are out there. I mean, I do think that there's some promise in all of this too. There are models that are out there, but we don't often compare them as much as we should, or pull out some of those good provisions and try to highlight them as potential examples. One other thing that I think we maybe don't do as often as we should is empirically study some of this. You know, how do we really make sure that we're doing our homework, that we've got, you know, we're not just making it up, we're trying to, you know, base it on actual, you know, priorities and interventions. So I turn maybe back to you. Pushkar, what do you think is, you know, could help here? Do you think more empirical study? Do you think a different way of kind of identifying and prioritizing some of these real needs? What would your suggestion be?
No, I think empirical studies would definitely be an aspect in terms of how we find a solution. I think, like Jamshed mentioned, empirical studies forms a core element of sort of sociological methodology. Yeah. How do we capture the lived experience? And I think the issue with us as international lawyers is that we often fall under the usual sort of dry analysis, where we're looking at treaties, we're mapping them, we're trying to see trends, and we're trying to see possible motivations. We're talking to state representatives to really understand why they've chosen this particular language and why have they focused on this area. And I can tell you from my experience with trade negotiations is that, for instance, just purely in the context of stakeholder consultations, it's extremely limited. We're really only focusing on regulators and maybe, and this is not something that us as lawyers are really privy to, maybe a handful of sort of private actors. But to really have a representative sort of consultation, I mean, it's difficult for me to say that we need to have more holistic consultation, because people don't fully understand the impact of international legal norms or international economic legal norms. We'll have to go through a massive amount of sort of education or re-education in terms of understanding the interconnection between the international and the domestic, and following which you need to essentially give them the capacity to now make comments, to now participate, and that's going to take too much time. And I think this is where empirical studies really helps in, is that now us as researchers have a key role in terms of trying to capture that lived experiences. And if I may borrow from Professor Schaefer's sort of methodology in emerging powers, it's to go through this sort of structured interviews and questionnaires, talking to negotiators, trying to understand their change in position, really going through these interviews and talking to people, that's an effective way to capture context. But of course, I think the ultimate goal is that everyone can be consulted. But the question is, how can we do that?
I think that's excellent. And I'm a big believer also in using interviews and consultations, both structured and more open-ended, sometimes surveys, depending on, what kind of instrument you think is going to deliver the kind of data and research that's needed. But I think that can also, those methods have been very useful, I think, in my experience also in talking to stakeholders, in talking to women, in talking to small businesses, and talking to local communities to try to understand their needs. How you design the questions is always a big deal, right? Because I found very early on when I started doing this work, you don't really want to you don't want to start out by asking about a trade agreement. You will not get answers that are necessarily going to give you the kind of, input that you need. But if you can find a way to actually talk about lived experiences, then I think it's very different, and that's where your socio-legal model comes back in. So I wonder, Jamshed, what would you add to this in terms of empirical, the value of empirical studies or other methods?
So I also sharing the same experience that Pushkar has told. Actually, I have written the same approach. That's what let me tell you that one of the important aspects to generate context is the diversity among stakeholders, and you have a diversity of stakeholders that they can inform their concern to set the context. And yesterday that Professor Sefer has also mentioned that the legal capacity building and this stakeholder consultation is also an important aspect, and I believe is one of the important aspect to address the issue related to developing context. And that's not only that Pushkar is just talking about these very limited stakeholder in terms of there are some regulators or some industry people are represented. The issue also pertaining these the diversity among them, how many SMEs represented, how many that people who are among the civil society has represented. So these are these problems that we have in order to get context for these issues at various forums. So this is one important aspect. I believe that the stakeholder consultation is important to address these problem of setting context.
Excellent, absolutely, absolutely. I think it's a tremendously important tool. How can we learn from each other better? There's so much good work that's being done. I've been really, I think, amazed to hear about all of the things here, over the course of the last few days, and just spent a few days with Professor James at CTIL, having some of these conversations too about how legal education and clinical legal education can play a role in all of this, how we can maybe exchange information, and maybe we do need to just spend the time and sit down together and really talk through some of these things that we've tried, things that have worked, things that haven't worked, things that we can learn that are very context specific. But any thoughts on that? How can we do somehow, as a group of scholars and practitioners, how could we do a better job trying to understand where some of these local approaches really come up in different contexts?
Yes, thank you, Chair. I think it's somewhat hardest part of an academician. Because if I am a practitioner, yes, I would have come across what all practical issues which are presented, as both of them have rightly recorded. So who should be consulted, when should be consulted, where should be consulted, why should be consulted, how should be consulted, what should not be consulted. So these parameters could be delineated only based on a problem. So as a student of law teaching the course, I can teach based on data which is presented. I can directly refer any decisions, is it by local courts, regional courts, international courts, or dispute settlement body like. But I can't make a hypothesis unless I intended to collect data. So for methodology could be applied to teach. It is not only interdisciplinary, it should be transdisciplinary. Because as our co-panelist was rightly mentioned, it is not a discipline, it is a subject. When you take a subject, we can literally identify what is the perspective of economist, what is the perspective of anthropologist, what is the perspective of historian, what is the perspective of management, what is the perspective of the practitioners like. Because where they will come out with the data by saying, okay, so this could be the model we can follow for this particular perspective. So after having some data, then they may think of to have 1 or 2 clinical trial like what science are. So where we can follow that clinical based education. So till then I think it's only an assumption. This is not my find. But the one thing is certain, the institution whichever involved has to engage in the name of a harmonization process. Because the early 90s were only delineation between which could be enforceable, which could be non-enforceable. Now we are in the era of sustainability. If not all, I would encourage all of us to have a deeper understanding on goal number 16. It is very, very, very novel goal. What does it say? How you can integrate the existing instruments, if not institutions. When you have, as afternoon session when they responded to our Pushkar, both James sir and Wagner, they said, first you have to go and verify the data. Mere observation or panel discussion, whatever, make a finality in a particular case, EECL case, would not be. So therefore, coordination amongst the institution would give a better result. That's what in 1970s our Prime Minister happily recorded. In India, if at all you want to translate whatever codified in the international plane, should be thought of to local. So they use 3 interesting concepts: think globally, act locally, and do domestically. If you are efficient to implement from the grassroots level, you will realize anything, not in the name of legal as I began, it's in the name of equity. Thank you.
Very nice. And I think that holistic approach is definitely something that's come through in this conversation and many of the others, that we have to approach this at all levels. That even if we are focused on the local, we have to think about the institutional level. We have to still think about the very high level international law, but we have to make sure that this piece is being prioritized. Any thoughts, Pushkar, too, on this question of how we could kind of collectively collaborate a little bit more, or perhaps where you think also the scholarship, could go moving forward? What do you think some of the opportunities and gaps perhaps are on those levels?
I think if I can be permitted, if I can just step away from being providing a theoretical approach, because that's all I've been doing, and I can sort of recall what Professor Lela mentioned yesterday, is that we need to start thinking about climate financing as something that can bring in money. And I think this is where we can sort of look at why we should involve local actors as economic actors. They're equally important. They can bring in finances. They can be equally valuable. And we always look at, for instance, I remember coming across this one example that Sergio Puig mentions in terms of how indigenous peoples can be effective economic actors. And he gives the example of a Hard Rock Cafe. It's a big restaurant chain, and it's run by the Seminole tribe based out of Florida. So it's a business that's worth a couple $2 billion, but then essentially once you start looking at them, reimagining them, whether it be women or MSMEs or indigenous actors as economic actors, we can really shape why we should try to reshape how to look at them and how international economic law should be geared towards them. And even in terms of, say, climate action, and I'm sort of moving away from international economic law here for a second, is if you look at the bushfires in Australia, for instance, one of the reasons that was attributed to it was that the regular sort of burning of old bush by the indigenous communities in Australia was attributed to the reason why it sort of spread like wildfire and caused immense damage to both property and wildlife and vegetation. Is that we didn't account for something as archaic as that as being effective ways to stop a climate disaster. And again, this comes down to, we need to reimagine how to look at this.
Absolutely.
We need to re-look it. And once we look at it as economic actors, once we start providing an economic incentive for that. And I remember talking to an Australian negotiator on this when they're talking about this bushfires, is that they were looking to provide carbon credits to that. And they were engaging with the IPCC, which is constantly in discussions in terms of carbon credit classification, is that once we start looking at these indigenous practices, carbon credits, that provides an economic incentive for the state to sort of change this way. But the first step is, of course, as researchers, is to identify the economic value and to to look at them and through these different lenses, not just as actors that required some sort of protection or safeguard, but as ones that can bring in money, and also and for the state to provide some sort of protection for them to continue bringing in more money.
That example I know was in a paper Professor Gathi wrote as well, right? Because I cited that in my paper, and I thought it was such a good example of having almost some solutions right there in front of us and overlooking them. And this is one of the things that I have found working at this very granular level for a long time. And part of the reason that I decided to write the micro international law paper is because I feel like we are getting to a place where we really need to mainstream this kind of approach. And so this is my last question, maybe, you know, is there, how can we do that? How do we keep this kind of thing from happening over and over? How do we make sure that there is proper value placed on these solutions that are very local? How do we ask questions about them? How do we learn about them? This is partly why I also think that, like, changing some of our methods so that we get at the very granular can also have a real tremendous impact. So I'll go to you for that final question, and then we'll turn to the audience for their questions. Any parting thoughts on that?
Yeah. So just I got to say that, of course, that the clinical legal education that you have taken the example is one of the important, and as a part of the trade lab, I must say that's a really great initiative. But one thing is that we have to think that whatever we are producing through the trade lab, let's say, for example, I'm giving the example, let's say the report has come, what's the value, to what extent that report can travel? Is that the report is just looking into the compatibility or non-compatibility issue, or also address the issue that who are going to impact it? So to whom we are intended, we are intended to particular industry only, that we are creating that report, or it is showing something more? So in terms of changing approach, not only the addressing the issue of legality, but also the actors who are going to impact by those action may also be addressed in order to make it more approachable or more comprehensive in terms of it can be valuable for the other actors also, rather than only industry or particular lawyers or the field that who are working on that. So it is one way to make the particular things is more valuable in terms of the impact. That impact is not only for industry, that may be other actors. Just because the industry is approachable to you, or you are approachable to industry, that does not mean that you should limit your study to that level. So this is one way to look what a different methodology we can adopt to make that particular result is more inclusive and conclusive for that matter. So that to it given a example that can be courage.
Excellent. Well, thank you for bringing it back to clinical legal education, because, as I mentioned, some of us were at a conference hosted by CTIL in Delhi just a few days ago and focused on clinical legal education and the role of clinical legal education. And I feel like some of the takeaways for me from that discussion come back to exactly what you were saying, that this is about social justice, this is about equity, this is about sustainability, it's about a reframing and a rethinking of the norms, and that is one of the ways that we can see that shift in action. So I really appreciate that. So I'm going to now turn to the audience, everyone here with us, who many of you have done substantial work in this area. Would love to hear your questions and comments for the panel. So I think there is a microphone. There it is. Okay. Thank you. Please.
All right. Thank you very much. First and foremost, thank you, because they're really excellent, super interesting, fascinating. My question, comment, you may have worked on the plastic treaty. Plastic treaty is often an example given by our political science colleagues for what they call polycentric governance. So it's a way of treaty making which is slightly different in the sense that it's not, top down, the state, but basically we ask inform, ideas from the public and so on and so forth, right? So this works for plastic because nobody wants to see a poor dolphin with some plastic in its mouth. However, when we come to grave violations of international human rights, grave violation of international humanitarian rights, which are happening right now, when we talk, nobody's interested in polycentric governance. while these have massive implications on international economic law, right? Sanctions, for instance, investment in war zones. There are investments in war zones, and so on and so forth. So what do we do with that? I find that the world we live in is particularly unstable, particularly arbitrary as well, and that we will have to be extremely pragmatic and adapt probably very differently, I don't know whether you agree with me, to different contexts. Plastic is one thing, that's fun, everybody wants to deal with plastic, it's nice, it's not too political because nobody wants to eat plastic. But, you know, wounded babies, school erased from the planet, the surface of the planet, nobody wants to talk about it. So how do we adapt to these very blurred sort of realities and this constant arbitrariness?
That's an excellent question, and I know one that will carry into some of the other panels that are to follow. Should we maybe take a few questions together and then we can kind of give them to the panelists to respond? Marcus?
So I'm gonna live up to my reputation and play the spoiler. And I'm going to ask you something, and I'd really like a frank response, right? So I find the panel fascinating. I also largely agree with what you said. I've used qualitative methodology. We've done 100 interviews on a project on weaponized trade. All good. Pick your favorite one, methodology that you think is the best thing since sliced bread, and critique it. And tell me what the negative sides of it are. Because the one thing that's missing, and I know you can say, well, it's always been there, is sort of the positivists on the panel that would say, here are some really good benefits of positivism, right? So I would like to hear from, and because you've all sort of poo-pooed a little bit the positivist side. And as a German, I sort of say, sometimes it might actually have some great utility, right? So what I would like to hear is, are there any, in your minds, any downsides to clinical legal education? And I can think of plenty. Because you can't finance it in law schools across the board. It's expensive, right? So I just would like to hear whether it's TWAIL or whatever approach you think is really great, and we've heard that, what are the downsides of it? Are they replicable? Is there anything that we might have to change in order to make them even better? If you want to put a positive spin on it.
Good question, and always one that we should be asking ourselves. I agree. Was there one more question maybe to, yes?
My question is to Professor Amirthalingam. So in terms of bringing equity in the aspect of international economic law, a lot of the earlier Indian cases were also based on equity, where the approach was guided more by an anthropocentric approach, wherein the court held that environment would not overtake the economic aspect. Similarly, we have a lot of recent decisions where this has changed. So my question is, now when we move for a more ecocentric approach, it's still guided by equity. But is equity a necessary or even a sufficient condition to help address this problem? Because the norms which govern equity are something else. For example, here, anthropocentric or ecocentric. So how do we resolve that aspect?
Thank you.
Thank you. Okay, Professor, maybe I'll start with you since you had a question addressed specifically to you, and feel free to comment on the other questions as well.
Yes, thank you very much for your clarifications. When we take about the effective conservation of the resources, there are two approaches. What you rightly mentioned was correct. Is it of anthropocentrism or ecocentrism? The base in which I made my submission, based on what literature the institution may think of to decide. Is it based on what is codified like X or Y in the name of international economic instruments, in the name of environmental instruments, IPR instruments, or investment instruments? In all these common examples what I gave, the missing part is which is universal in common. That's what we are describing in the name of equity. That's what I pose a simple statement. Non-absence of a provisions in any one of the instruments or the institution is no more a license for the investors to otherwise use, misuse, abuse, or non-use what he was using. Okay? So when there is a mechanism If the mechanisms are not otherwise effectively used, then your observation was correct. Because climate change, when you said, yes, we have a UNFCCC, we have a COPs, we have IPCC report. Morning also, I think he was referring with IPCC report. These reports says what are the effective contribution of these participating states to fulfill the targets. Again, I am stressing whatever is accepted. Here we are speaking what is not available in the instruments. When there are gaps, that's what even I began with the sources. Anything which is otherwise accepted in the name of generally principle, like universal in nature, no one can easily observe. If there is an attempt, then question of sustainability comes in. What is your aims at? Are you going to simply quantify your GDP or human development index? Are you going to simply eliminate the people from the Mother Earth? Choices are yours.
Thank you very much, Professor. And we're getting close to the end of our time now, but I'm going to turn to you two with these other two excellent questions on polycentric governance and what are some of the downsides to these models, which we probably could spend the entire afternoon talking about, by the way, but we only have 2 minutes, so go ahead and answer as you see fit.
I don't think I'm the right person to talk about polycentric governance. I hope that's okay. But I can take up Marcus's question if I can. And I think in terms of looking at the flaws within these methodological approach, there are flaws. I think TWAIL itself is not a complete framework. It's simply just a critical lens. I wouldn't even categorize TWAIL as a methodological approach. It's simply a way to critique, and that being the reason to look at other approaches. So even if you look at, say, the recent publication by Naz Modizadeh, it's really sort of a polarizing piece in terms of looking at the critiques of TWAIL. Let's dive a little bit. And I think there she talks about the idea that as practitioners, there's really little that TWAIL offers. And I have to admit that's partly true. But then I think what others would say is that it's not meant to form a solution. It's meant to critique. Even what Gati is talking about in terms of promise of international law is that TWAIL creates a critique, and then you look at other ways to find a solution. And I think Professor Kuhlmann's sort of approach in terms of looking at micromapping is a possible methodological way to look at this issue. And I guess with positivism, I think my only concern with it is that it's sort of the step after the text is created. But what is the basis by which, like Jamshed said, what is the context and the subtext that led to it? So as a positivist, I can say that the benefit is that you can simply sort of distance yourself from some of the controversy and politicizing the issue, which is its own benefit. But then it takes away from why did this text even come to place in the first place.
I think the context has to be built in. I think you can't. But I think with the challenge with a lot of these models is they take so much time, right? It's very hard to replicate and do them at scale. And that, I think, is one of the big issues with the micro and the local sometimes is how do you bring it back to really influence that high level that is moving on its own time frame. Jamshed, I'll give you the last comment here. What do you think?
Brief. I 100% agree with the Pushkar what he has told. Just basically that every approach has a flaw. Just what we have discussed, as Professor Kuhlmann says, the problem of getting context. It's a kind of problem in its approach that it's not easy to get context and become more complex when you are locating sub-context. So this is the thing that every approach has its own merits and demerits, but the point of adopting a different approach is to get a different picture of a particular scenario, and that's why we discuss a different approach to assimilate as the theme says of local actors. So a social legal approach is the one way to locate where the local actor actually stand. So tell me any approach that does not have any flaw. Of course, it has flaw, and we have taken the issue of the context of these, that generating context is not an easy task while taking these socio-legal research. So that's why I want to conclude here.
Well, I think this is fantastic to have these conversations, and I think we need to do more of this because it seems like from all of your questions and all of the great comments and input from this excellent panel, thank you all so much for this. We need to keep exploring this and keep testing things and keep refashioning them and re-evaluating. So thank you very much. I really enjoyed the discussion. I hope you all did too, and we'll have to continue it. So thank you.
Thank you.
Thank you all for such valuable contributions. Let us take a moment for express our deep gratitude to our respected panelists for sharing their valuable knowledge and expertise. These tokens represent our heartfelt thanks for your time, effort, and dedication in making this discussion such a success. So, let me cordially invite Professor Katrin Kuhlmann to distribute the token of appreciation. I would like to invite Professor Amirthalingam. Mr. Pushkar Reddy. Mr. Jamshed Ahmad. And I also invite Professor Katrin Kuhlmann to accept the token of appreciation.